Hello guys, and welcome to another episode of my lecture. Today we will be talking about de jure and de facto directors. So let's go straight to the class. So according to my note, it tells us that de jure director is a director who is duly appointed and recognized by law. And as such, section 269 recognizes de jure directors by talking about those that have been duly appointed. If you go back to my last lecture, I stated the fact that section 269 has two parts. The first one, it tells us that directors are those that are duly appointed to direct and manage the business of the company. You see, the fact that they said duly appointed there shows that they are referring to only de jure directors. Under section 2691, they are referring to de jure directors alone. Do you understand? They are recognized also under section 868 under the umbrella of whatever name called. The fact that you have duly appointed this director, and then the fact that you call him whatever name, either chief executive or whatever you decide to call him, the question that we should ask is, does he manage the business? Does he direct the business? That's number one. Number two, was he duly appointed? If he manages and directs, and if he was also duly appointed, then we would regard him to be a de jure director, not a shadow director, not a de facto director, but a de jure director. Do you understand? Now, the law recognizes persons who are also de facto directors. These are people who haven't been duly appointed as director but occupy the position and function as directors. Do you understand? They purport to act as directors even though they don't hold the office of directors as of right. They are not directors in law but directors in fact. Do you understand? Directors in law are de jure directors that have been duly appointed. Directors in fact is that they are managing the business of the company. They purport to act on behalf of the company, but they have not been appointed in law. Because of section 868, the fact tells us that they are directors. So for you to understand the function of a director, you must read 868 by whatever name called. Read it with 269, manage and direct the business of the company. Whoever, by whatever name called, manages and directs the business of a company is a director. So whether or not you have been duly appointed, if you are duly appointed, you go under section 269. If you are not duly appointed, you come under section 868 first leg. For de jure directors, they also come under section 868 first leg, but de facto directors as well come under section 868 first leg. Do you understand? Now, a combined reading of section 868 first leg, section 269 sub 2, and section 276 of CAMA shows us that the law recognizes de facto directors. Section 2692 of CAMA, which says that there is a presumption in favor of a third party dealing with a company that all those who are described by the company as directors, whether executive or otherwise, are duly appointed. Do you understand what that means? There is a presumption when a third party is dealing with a particular company. For those people that have been described, the word used in section 269 subsection 2 is described. For those that have been described by the company to be its directors, third parties can say that yes, these people have been duly appointed, and therefore the company is bound. But for the company to be bound, there must be a representation by that company to the person that is dealing with the company. So we then move on to section 276 that says that where a person is not duly appointed as a director but acts as such on behalf of the company, his act does not bind the company and he is personally liable for such action. But where it is the company which held him out as its director, the company is bound by his actions. Can you see the synergy between 868 first leg, 269 sub 2 and 276? 868 tells us that the director is a person occupying the position of a director regardless of whatever they call him. That's by whatever name called. Do you understand? Now 2692 tells us that where you have a third party dealing with a company, the company shall be bound where the company describes him. Now, when you get to 276, it says that a person who is acting as a director, where he holds himself out to be a director, the company shall not be bound. Only where the company held him out. Those are the words of Kama. 2692 says where the company describes him as its director, that is when the company will be bound. So 2692 gives company liability, but 276 gives both personal liability and company liability, where the company knew that he was acting and then must have acquiesced or must have done an overt act to hold him out as its director. Do you understand? So you see, the question about section 269 sub 2 is that what constitutes a description, and how can a company describe a person to be its director? Every description by a company that one is a representative, for example, a list of director in a company's document, is a description. So when I was teaching, a group, I told them that imagine Davido's father, who owns a particular company, decides to add Davido's name in its company. Even though Davido is not a director, he decided to write David Adeleke in one of the company's documents and gave it to a third party who contracted with that company. That would be a company describing Davido as a director. Do you understand? So Davido here might or might not be a director, but when his name is in a company's document that has the list of directors, his name is there, and then a third party who is contracting with that company sees that particular document and contracts with the company, it is deemed that to that third party there is a rebuttable presumption that Davido is a director and that he has been duly appointed. Do you understand? That's what section 2692 is telling us. When you go to section 2693 of Kama, it punishes persons who, though not appointed, act or hold himself out as a director. Now, Professor Bolode Oku, the Dean of Faculty of Law, University of Lagos, seems to have a problem with this particular provision because he said that it is quite problematic. Why? He said that it is quite impossible for a person to hold himself out. For you to talk about a holding out in law, a person must have been represented to be something by another person. That means a person cannot unilaterally hold himself out to be a director. That's basically what Professor Bolodioku is saying regarding section 2693 of Kama, where it prohibits and makes it a criminal offense for somebody to hold himself out as a director. The use of the words hold out in section 2693 may have been a mistake by the draftsman. Section 2694 punishes the company for holding out a person not duly appointed as director. So, as we can see from our discussion, the judge director is basically somebody who has been duly appointed. Section 2691. Abi? Now, when you are talking about de facto director is someone who has not been duly appointed but who acts as a director. Now, both of them are supported by the first leg of section 868. But when you are talking about de facto director, you go to section 2692, which says that when you are talking about third party transacting with the company, there is a rebuttable presumption on behalf of third parties that any director that has been described so by the company has been duly appointed. The word there is described. Do you understand? When you go to 276 of Kama, it tells us that where a company holds out a person to be its director, then the company will be liable for the act of the person. But where the person holds himself out, then the company will not be liable. Do you understand? And then when you go to section 2693 and 4, 3 tells us that a person will be criminally liable for holding himself out. 4 tells us that a company as well will be liable for holding a director out when in 3 and 4, the both of them, they know that that particular director have not been duly appointed. So in 3, he knew he was not duly appointed and he held himself out to be a director. In 4, the company knew that he was not duly appointed yet held him out to be a director. In both cases, 3 says that the person himself will be criminally liable. In 4, the company would be criminally liable where the company held him out. Do you understand? So on that note, we then go to shadow directors. Who are shadow directors? How did they become shadow directors? And all of that. I'll see you in my next class.